So with that, let me end, and I will introduce our next speaker, who's going to talk about the most important law that election researchers have to be concerned with, which is the Digital Millennium Copyright Act, and how to not run afoul of that. So please let me introduce Tori Noble from the Electronic Freedom Foundation, Frontier Foundation, who will talk to us about the DMCA. So thank you, Tori. All right. Do you want to use the podium or the... Oh. Go.
Thank you.
I think you have to select it.
Oh, right. Sorry. Thank you. Should I give people a minute, or should I start?
You're on.
Okay. Hi, my name is Tori Noble, and I'm a staff attorney at the Electronic Frontier Foundation. And I'm here to tell you all what you need to know as election security researchers about Section 1201 of the Digital Millennium Copyright Act, or DMCA. Briefly, just a little bit about my organization. At EFF, we strive to protect digital liberties, including privacy, security, free speech, and innovation online through legal advocacy, policy work, and public education. You can visit us if you'd like at our DEF CON booth or at EFF.org. As a general disclaimer, this presentation is not legal advice. It's being given for informational purposes only, and if you need legal advice, please contact info@EFF.org. So what is Section 1201 and why should you care about it? This is a 1990s anti-piracy law that was never intended to have anything to do with security research. But unfortunately, over time, it became one of the largest legal barriers to security research in general and election security research in particular. That has some very narrow statutory exemptions that were insufficient to protect researchers and avoid the chilling effects that happen because of this law. Fortunately, security researchers, including many of the leaders of the Voting Village, worked with the Library of Congress to secure a temporary administrative exemption that is much broader and does protect much of the research that we'd like to happen on election security and security in general. Section 1201 has two provisions. The first and most important is called the anti-circumvention provision. It makes it illegal to circumvent or bypass or remove a technological measure that controls access to a copyrighted work. The second provision is the anti-trafficking provision, and it makes it illegal to manufacture or sell any technology that is primarily designed or produced for the purpose of circumventing a TPM and has few other commercially significant purposes other than circumventing a TPM, or marketing, or it's marketed for circumventing a TPM. So what does it mean when we say don't circumvent a TPM? So I think that requires looking at what a TPM is. A TPM, or technical protection measure, is a digital protection that controls access to a copyrighted work. So it's a technological barrier to access. For example, would be digital rights management, like you'd see on video games or DVDs back in the day, encryption, CAPTCHAs, things like that. However, not everything is a TPM. However, I will say, before I go into this, trying to rely on something not being a TPM is actually quite risky, because some of the things that do not count are technological measures that protect non-copyrightable material, such as purely informational facts. However, copyright is so easy to obtain, the bar is so low, that a lot of informational works actually are copyrightable to some extent. So that is very difficult to rely on without counsel. Also, measures that don't implicate any rights under copyright. So that would be things like features that limit where you can view a video, for example, so location restrictions. And one example, there's very little court law on what a TPM is and isn't. One thing that we do have some cases on is the unauthorized use of a valid username or password, so using someone else's login credentials. Most courts have said this is not a TPM, so it's not covered by the DMCA. However, at least one court in California has disagreed, and most jurisdictions haven't weighed in on this, so we don't know for sure. Okay, so those are TPMs, and what you can't do is circumvent them. What is circumvention? Circumvention means bypassing or removing a technological measure without the permission from the copyright owner. So this is decrypting an encrypted work, bypassing a login gate, things like that. Penalties for violating the CFAA are quite significant. There is the potential for both civil and criminal liability. Criminal liability is for willful violations for the purpose of financial gain or commercial advantage. But even civil liability can result in very high fines that compound very quickly, because there are triple damages for repeated offenses, and if you're circumventing things more than once in a course of a project, that can add up very, very fast. So staying within the confines of the DMCA is important. There are 2 statutory exemptions in the DMCA itself. However, these are extremely limited and in practice proved extremely insufficient to protect security research, even though they are designed to. The first is the security testing exemption, which covers good faith security testing, but you need the authorization of the device owner. So if you're trying to hack a voting machine and don't get permission from the voting machine company, you can't rely on this exemption. So that makes it extremely narrow. Another narrowing factor is that you cannot violate copyright or the CFAA, which is the Computer Fraud and Abuse Act, the other major source of liability for computer security researchers. So those both would vitiate your exception. However, one positive of the security testing exemption is that it does apply to anti-trafficking. It's actually the only one that applies to the anti-trafficking provision. The second, which is also very narrow but slightly broader, is the encryption research exemption. This covers the investigation of encryption applied to copyrighted works. You must have made a good faith effort to contact the copyright owner, although you don't need to be successful. So if you try to reach them and ask and they don't say yes, that's still good enough for this one. However, the actual application of this exemption relies on several factors that courts have not really evaluated sufficiently for us to know where the precise boundaries are. But those factors include things like whether your research would advance knowledge and understanding of and development of encryption technology, or whether it would facilitate copyright infringement, on the flip side, whether the researcher is themselves a student in a field of study related to encryption, or a professional who works with or on encryption technology. So it requires a professional or educational background. And also whether notification was given to the copyright owner of the vulnerability that was discovered. How those apply and how courts would weigh them is unclear. So this is a little bit ambiguous, quite ambiguous. However, fortunately, there is a much broader temporary administrative exemption. When, for quite a while, Section 1201 was a significant barrier to security research, but then security researchers, including, again, some of the leaders of the voting village, got together and petitioned the Copyright Office for a new exemption that would cover good faith security research, but do it in a broader way so that it would be more applicable to the kinds of works that are important or the kinds of work we would like to happen in this field, and to avoid the chilling effects of this not having a broader exemption. This exemption requires that your access have been solely for good faith, solely for good faith security research on a lawfully acquired device or with the permission of the copyright owner. Your access may violate the CFAA, and most importantly, you do not need authorization from the device owner. This does not apply to anti-trafficking, and it actually expires in a year because this must be reauthorized every 3 years. So it's not guaranteed to exist in the future. Actually, petitions for renewal are due in a few weeks. So this is a fragile exemption, but so far, historically, it has been renewed every year since it was adopted, and it's been significantly expanded. So the trends support continued existence of it. However, the administration could change its mind, which creates some uncertainty there. So one of the requirements for this provision or this exemption to apply is that your access was solely for good faith investigation of a vulnerability. And the requirement that it have been solely for the good faith investigation is that if you started by doing something else and then found the vulnerability and investigated it, reported it, that actually wouldn't be covered under this. So that's unfortunate because that limits out some actually really valuable work that happens, but you have to have been solely accessing the device to do your security research. You also have to have been accessing the device in an environment designed to avoid harm to any individual or to the public. This is effectively a good practices requirement. So in particular, it's important to make sure you're avoiding inadvertent disclosures of personal information, creating more vulnerabilities that might be exploited, things like that. So best practices for conducting research in a safe and responsible way is likely what that requires, although to my knowledge it has not been litigated, so we don't know how a judge would draw the lines there. And then lastly, information cannot have been used to facilitate copyright infringement, and it must primarily be used to promote safety and security. The second requirement for this to apply is that the research must have been conducted on a lawfully acquired device. And this is somewhat ambiguous, and does create some uncertainty about whether the application applies. So it's a less than helpful provision, but it likely is satisfied if you purchase a device from a manufacturer and probably from a third party, although there's some gray area there. And borrowing a device from a third party likely also qualifies if that third party themselves lawfully acquired it. So there's a potential that this may hinge on someone else's lawful acquisition of the device who loaned it to you. But in particular, the biggest source of ambiguity here is that there's the potential argument that voting machine companies have made that contractual prohibitions that they insert into their sales contracts for voting machines that ban resale, that those provisions may be enough to make you not satisfy the lawfully acquired device requirement. I think that's debatable. Courts have not weighed in. However, voting machine companies have exploited this ambiguity and made this argument in threats to researchers. So it's important to keep in mind, but again, it's ambiguous and we don't know the answer to whether or not that is a valid argument. Because of this ambiguity, if possible, it's best to get written authorization from the device owner. If possible, it may not be, but to the extent it is, that can help eliminate any ambiguity here. That said, despite the ambiguities and the need for renewal, this temporary exemption has had a really important effect on security research and in particular election security research. It actually is what allows the voting village to exist. It was created after this exemption was adopted. And what's also really cool about this exemption is that it was created in part to protect election security research. Some of the petitions that the Copyright Office cited as evidence for why they were adopting this were submitted by some of the leaders of the voting village and other election security researchers who highlighted the need for greater protection for people doing this work. And the 2024 rule actually specifically highlights the critical need for election security research on voting machines as a justification for continuing to provide this carve out from liability. So that is extremely significant. That said, it isn't perfect. There are a few things that still create difficulties, even though the exemption does exist. It's ambiguous. Like I said, the lawfully acquired device rule in particular creates uncertainty. And there's also limitations stemming from the rule that access was solely for good faith security testing, which again, the boundaries are a little fuzzy, but that is a limitation. There's also the problem that the exemption must be renewed every 3 years. Again, it is likely, hopefully, based on history alone, that's all I know, that this will be renewed. It has been every time it's come up in the past. It's also been significantly broadened in several rulemakings. So the trends are towards maintaining and even broadening this exemption. However, it's not guaranteed to apply, and the administration can, like I said, change their mind. Additionally, risks still remain under other laws. This exemption only gives you protection from Section 1201. It doesn't shield you from the CFAA or copyright infringement liability or any other source of liability. That said, the security temporary exemption has provided much more protection than security researchers had in the past and is vital to empowering the work that happens here and allowing it to continue. And I'm happy to take any questions, if anyone has any. Yes.
An IP or some more patents, but a little bit of controversy. How does fair use, like the general common law fair use, sort of fit into some of, like, I think you have a research, a statutory research exemption, but I know that there should be a common law fair use exception as well.
You are right that there should be a fair use exemption or exception. There is not. So fair use is a concept in copyright law where uses for example, educational purposes, transformational uses where you're using a work for something, to create something new or for a completely different purpose. Things of that nature are protected from copyright liability. However, even if your access here, if you circumvent a provision, your access will, even if your access would not violate copyright law, you would still be liable under the DMCA if you circumvent a TPM. So good faith, unfortunately, doesn't apply, and that's why we need statutory and administrative exemptions.
One follow-up question. Has there been litigation to sort of knock out or try and knock out on constitutional grounds the whole DMCA statute?
I believe so. I think that happened before my time, but I think EFF was involved. But yes, I do think that has happened. Good question.
So TPM stuff, I'm just speaking as a developer day to day. I'm very used to buying a library, thinking to find functionality I want, say I can't do it, they get to the library and say, oh, this function is hidden with these new parameters, and I just do pointer method and everything else, I'll make it work. Is that violating TPM? Because I've been doing that for 30 years.
So it depends on whether the thing that you're doing that to access, whether the thing you're accessing is itself copyright protected, and then also whether your work would be covered under the exemption.
So it's definitely licensed software because there's open source languages that go in pre-compiled Gemini. It's definitely licensed software.
So if I could just ask, we don't have an audience mic because we're extremely organized. All the talks are being recorded, so in order to answer the question, I'm going to ask the speaker, not just you, to summarize the question for us. Thank you.
My sense from a lot of the analysis that's been done, especially about the changes to the DMCA, technologies, is largely focused on coding machines that we have in next to the store. Do you know how transferable those properties are to other election technologies, especially like software as a service style of whole orchestration ecosystem, or is that just not thought about there?
That is a great question. So the question was, we're thinking here about election security research on voting machines specifically, and how transferable are the principles I've talked about to other kinds of election technologies like software as a service. Is that correct? Okay, cool. So two answers. One is that there actually isn't a lot of judge-made law on even voting machines. So a lot of this is really just lawyers looking at the law and making our best judgment. So actually the same principles would apply there, but how they would apply is of course uncertain, as it is for voting machines. Yes.
What kind of case would need to be brought before courts in order to most best establish sort of case law you want for this sort of thing?
That is a great question. The question was, what kind of case would need to be brought to best establish the law in this area that we would like to develop? That is a great question. Likely, unfortunately, the best, strongest case would have to be someone who has been sued for violating Section 1201. However, it is possible under some circumstances to bring what's called a pre-enforcement challenge, which is asking the court for a declaratory judgment that because you face a very significant risk of liability under a statute, you're asking the court to preemptively declare that you're not liable. So if that's possible, there are rules, understanding, and procedural law that limit those cases, but it is possible and they have been brought. Sorry. Okay.
Just that regarding the date security that expires in 2007, who is lobbying Congress?
That is a great question. The question was, who is going to push for the exemption to be renewed this year? Actually, I don't know. In the past, it has been groups of security researchers, including some of the people who run the Voting Village. I will certainly ask if they're going to do that again this year.
So, with like a lawfully acquired device sort of statute within there, I know that there's a lot of laws within this research where it's like it's not unlawfully access like technological systems, and that's like so for like the lawfully accessible part, or like you need a lawfully acquired device. I guess where does scoping come into that? Like how would you even scope something like that with an engagement with, you know, the voting technologies company? Like, how is the scoping of the project or any of that work with the voting technologies companies? Like, could the voting technologies companies argue that any research on their systems is essentially unlawful because you don't give them the right to scope that sort of research, or we didn't give them the scope of that research or conduct that research?
Sure. That's a good question. The question was whether voting machine companies could argue that any access was unlawful because they didn't give them permission to use the device, I guess, for that particular research. You actually do not need the permission of the copyright or of the device owner to qualify for the temporary exemption. You just have to have lawfully acquired the device. So you can't steal it, I think is what that was going for. But there are arguments from voting machine companies that if their contracts with someone else said, do not resell this, and then they resell that to you, that you have not lawfully acquired the device, yeah. Whether that actually is valid in practice, I think remains to be seen, or hopefully won't be seen, but we'll see.
Following on to that, if an election owns the device, and it is the contractor asking the researcher to do this, with that convenience area, they're not reselling that.
That's a great question. The question was if the device owner is an election body, sounds like? Yeah. Yeah, someone who owns the machine, yeah, right, who's asking you to do the work, whether that is lawful acquisition, they're giving it to you to do it. That is likely lawful acquisition. Again, there are arguments to the contrary if they have a contract with the voting machine company. Right. I mean, I think, yeah, it depends really where the judges would come out on that question.
Just kind of to burrow down on this. So particularly the concern is that the no resell, that's kind of what you're violating on that. In the event it is donated or freely given with no charge, is that normally also covered under these voting machines contracts, or is that something they don't really expect because it's such an expensive piece of technology?
If the voting machine company was giving away the machines?
Or the election group, so like a state buys it, it gets old, donates it. Does that donation consider lawful acquisition?
Okay, so the question was whether a donation of a voting machine is considered lawful acquisition. Again, likely it would be under the best reading of the exemption, it should be lawful acquisition. However, again, there are still these arguments that voting machine companies can make because of the ambiguity of the language of the provision.
I think we have to end here. Thank the speaker, please.